Let's see. Senate File 123, Senator Latz. Let me make mention that this is an informational hearing, and there are no votes that will be taken. Testifiers, we'd like you to keep to about 5 minutes, and try to stay with the jurisdiction of local government. We understand this is the only meeting this will be in, and so I'm going to allow a little flexibility there if you stray off. But we're going to really try to keep to 5 minutes. Senator Latz.
Thank you, Mr. Chairman and members. The bill that you have before you is a response to news reports that a local sheriff's office was planning to delete emails after 30 days. And frankly, my reaction to that, thinking, well, that's not long enough for anyone to really have an opportunity even to think about whether or not there is something that ought to be kept for a while. Who knows what's in the emails. Obviously, emails have been the subject of a lot of discussion over the last several years. It's an angle on discovery for legal cases. It's an issue in policy making, and it's a concern about advocates for open government and accountability in government. So my reaction was one of great concern, and particularly when it wasn't clear from the news reports exactly what emails were being referred to. So my initial response was to say I'm going to get involved in saying that they ought to be kept for a longer period of time, at least long enough for people to start to think about it, and if issues come up, there's something available then for them to get information from the local government agency. As I started to dive into the issue, and I should also note that the policy of the local sheriff's department deviated from that of the county in which that sheriff was located. The county had longer retention periods for their email systems. And the reports weren't clear as to exactly what emails were affected. As I started to dive into the matter further and talk with more stakeholders about it, people that maintain these systems, I found that it's a much more complex question than simply one of saying all emails ought to be held for a certain minimum period of time. And certainly if you start looking at periods of time that extend beyond 30 days, extend beyond 6 months, extend beyond a year or 18 months, you are talking about massive amounts of email, a great deal of complexity with regard to the content of emails that may be affected, and the records retention statute, which frankly doesn't usually get much attention here at the legislature. There's advisory recommendations that are made, but most of the retention policies are determined locally by our local governments, and they vary quite widely across the state. I started to get input from a number of different sources, not only about this particular topic, that of retaining emails, but also about other updates that they felt needed to be made to the records retention statute. Some in response to Supreme Court decisions narrowing terminology over the years to what might have been the original intent of the legislature. The interaction between the Records Retention Act and the Data Practices Act. The different kinds of records that are retained by government, whether they be official records, whether they should be permanently retained, whether they're a public business that ought to be retained for a shorter period of time perhaps, but not forever, or whether it's an email that says, let's go have lunch today at 1 o'clock, I'll meet you over at Perkins or wherever. Or emails sometimes of a more personal nature as well. So then the question became, what should we do in terms of a broad brush legislation? I had a meeting with stakeholders last week, and they've been meeting before I met with them, and they've met since. My conclusion from that meeting was this is an opportunity for us to learn more about the system of record retention, but that we ought to move slowly and carefully so that we don't do any damage, and we think through exactly what it is that would be the best approach here. So I asked the chairman to convert this hearing to an informational hearing so that we can hear from some of the stakeholders, educate ourselves on some of these topics, and we can see if there is a consensus that develops down the road, or some minor things that we can do now and hold off on some major changes for later, or whether the best approach is something else. So for now, I'd like the committee to hear some of what I heard, and I will continue to listen and learn as I develop my thoughts on this process on the record retention as well. With that predicate, Mr. Chairman, I'm prepared to ask the committee to hear the testifiers.
Thank you, Senator Latz, and I appreciate your willingness to go through the process like this. When you have a bill, it's not always easy to lay it down and just do informational, but it speaks to your character on this. Let's have the testimonies of those. Let's, Mr. Gimberling, I see, and why don't we bring Ms. Gao up at the same time, and we'll go right in order as we have them here. Again, if you could keep to about 5 minutes, and I'll let you know once you hit that 5-minute mark. Mr. Gimberling, if you'd introduce yourself and continue. Good to see you.
Mr. Chairman, my name is Don Gimberling. I'm the spokesperson for an organization called the Minnesota Coalition on Government Information. We're an all-volunteer organization. Our focus is on information issues. At the base of our focus is the whole idea that, particularly in modern times, information is part of the way that we keep government accountable. As I said, we're all volunteers. We're a 501c3. Our membership is a variety of folks, former and current journalists, attorneys, retired attorneys, including me, librarians, and folks who care about information. And increasingly, we have technology members, too. We're kind of reflecting your topic today. I appreciate what Senator Latz is doing, because I've been hoping for about 20 years that the state of Minnesota would begin discussing just exactly how it wants to support its history as played out in government records. Before retiring, I worked for the state of Minnesota for 35 years. Part of my domain, as it were, a very small domain I'd point out, was responsibility for records management. By the time I inherited it, a variety of people above me in the food chain had decided, and I don't mean the legislature, I decided in the executive branch, had decided that this was not a function that was going to be heavily supported. So each time I would put in a budget request to increase that support, I would be told it was not a gubernatorial priority. And in the spirit of our organization, we're nonpartisan. That was true for both sides of the aisle, because I served under Democratic, Republican, and independent governors. So, now what's the problem with that? Well, the problem with that within your jurisdiction of local government is that there was a brief period of time, about 4 years back in the 80s, in which actually the state of Minnesota supported a records management program. It was in the statute a responsibility of the Commissioner of Administration, my bosses over time, and as part of that support, the Department of Administration offered support to local government to deal with records management issues. For example, out of that effort came the development of model retention schedules. And those retention schedules basically were designed so that local governments, particularly the smaller ones, would not have to do their own development, put their own time and effort into it. They could just adopt a model, because obviously across jurisdictions there's a lot of similarity of function, and when you have similarity of function, you have a similarity of records, okay? So that support was disappeared in the 80s, and at some point, if you want to get into the history of how that happened, I'd be happy to share it with you, because as some of you know, the chair, Representative Anderson, part of my role over the years has been institutional history about decisions about information. But again, I want to emphasize what's important here is whether or not the legislature is willing to step up at some point with important changes in policy and support for keeping our history, because that's what we're talking about. I was talking to a friend the other day, and I was reminded that when you go to a library and you wanted to research history, and I majored in history, and I'm still kind of a history wonk. One of the things you look at is the correspondence of a variety of people. If you go to a larger library, you'll see that a number of prominent people, large volumes of their correspondence over the years. Currently, much of that correspondence is in emails. And if the government is allowed to get rid of emails, and frankly a lot of other electronic records, only in the interest of efficiency, without considering the efficiency or without considering the value of history, we're going to lose something really important. So that 20 years from now, people will look back and say, how did the Metropolitan Sports Facility Commission make the decision to extend free tickets to various people in running a stadium? That's the kind of thing, frankly, that'll disappear. Obviously, I'm picking a hot-button issue, but because that's part of what goes on here. This is not about mundane stuff. This is about important history. You've got some written testimony from a citizen named Tony Webster. I'm not sure if Tony is going to testify or not, but Tony will show you in his written testimony how important emails can be. In the city of St. Paul, where I happen to live, which has adopted a very short retention schedule, some of the issues that would have been lost that have been publicly discussed are things like the mudslide on the west side of town, in which the city knew well in advance that there were problems with that, and they still let people go through that area, which resulted in the lives of 2 small children. And I think...
Mr. Gimberling?
Yep.
5 minutes goes really fast.
No, I understand. In conclusion...
But if you could, yeah, thank you.
And I will conclude. To the extent that, you want to hear more about the history, and if any one of you have questions about any of this, feel free to call me. Oddly enough, I avoid computers. Some of you know that. But my phone number is 651-699-6553, and I'm actually in the phone book. I went to a library in Portland last fall and asked to see a phone book, and the young man at the desk said, and I quote, "What's a phone book?"
Oh, really?
So, yeah. So,
thank you, Mr. Gimberling.
any questions I'd be happy to answer.
Thank you. Ms. Gao, if you'd introduce yourself. Good to see you.
Thank you, Mr. Chair, members. My name is Irene Gao, and I'm from the League of Minnesota Cities. I did want to start by thanking Senator Latz for having a stakeholder meeting that was actually quite illuminating in terms of all the concerns that we've had. And as he mentioned, stakeholders are meeting outside of the meeting that we had with the senator. In the course of the meeting and in talking to different people, I realized that there's some misperceptions that Senator Latz referred to, that cities or government entities have the ability to delete all emails if they adopt email retention policies. And that's not quite true. And just for a brief overview, I just wanted to talk a little bit about records management. Both Mr. Gimberling and Senator Latz did talk about it, as well as data practices. And the way that it works is, as Mr. Gimberling had started with, both IPAD and I believe it was also the Historical Society did create those model, or what we call general record retention schedules. And those schedules are then approved by 3 different state agencies. It starts with the state auditor, which is for financial value, the attorney general in the cases of cities for legal value, and then for historical value with the Historical Society. And for cities, what then happens is that the Professional Association of the Minnesota Clerks and Finance Officer Association regularly updates that general record retention schedule. And in fact, they're in the middle of an update now, where they're going to offer over 100 changes based on changes in the law and how technology has changed when it comes to records management. Now, the general record retention schedule actually has 29 categories and over 700 specific types of records. And so it's pretty broad in terms of what cities have to keep and how long they need to keep it. And you might be wondering, what happens if a city wants to adopt a different schedule? If they do that, or even amend the general record retention schedule, they still have to go through the same vetting process. Now, the intersection between that and then email retention policies is, let's say we have an email of a citizen that complains about a neighbor's junk in their yard, and it comes in an email. What happens then is that, regardless of the fact that it's an email, it could also come as a letter, needs to be kept for 7 years. The email retention policies that then get adopted are not about emails like that are official records. They are about emails that are outside of anything that might be an official record. So as Senator Latz had mentioned, emails that might be setting up a lunch date or confirming a room for a meeting, or maybe even email newsletters that we get would be outside. And those are what the policies then contemplate. Now, it also contemplates emails that might say to a council member, attached is an agenda. The email itself is not the record, but the agenda is, so we still don't lose that piece of it. I did want to speak a little bit to what Mr. Gemberling had said about historical values of communication. And for the city general record retention schedule, correspondence actually does have a historical correspondence category, which is kept permanent. And there is some definition as to what that's meant. And that is important to cities as it is to the value to the general public. Now, there is the added layer of, even if it's outside of the email retention policy as well as a general record retention schedule, if a data practices request comes in, that overlay, if there is a request that's specific for emails, any emails at the time that the city has it at the time of the request, it has to produce. So it doesn't necessarily matter that they could have deleted it. If the city has it in its possession, it would still have to produce it if it's responsive to the request. Now, Senator Latz had also asked in terms of what are some best practices, what are some challenges, and maybe some ways that the legislature could help. And in those ways, I would say what I've seen cities do really well is when they train their employees as to what types of records they need to keep. They contemplate that with the systems that they have in place. So some cities have very sophisticated email systems that allow them either to auto-delete or sort or archive, and some cities don't. A lot of that depends on the size of the city and the size of the staff. The training is helpful because in talking to one suburban city, what they do is they have a broader net than not. So they will train their employees and say, if you have any emails that's related to your work, I want you to put it into a folder that's going to be retained for 3 years. And that comes with every new employee. That's even outside of some of the cities that specifically have email retention policies. They have an all-staff training. And then each department looks at all the records that they have, figures out where they're going to hold it. And sometimes that's email, but most of the time it's not, because they want to be able to save the email systems specifically for email. And for records management, they have different systems for that. In terms of a way that the legislature could help, what has come to light is that maybe what would be helpful is for some state guidance. Now, I've already said that there is the records disposition panel, the 3 members that I just mentioned. But either additional support for them, or as Mr. Gemberling has talked about, maybe within IPAD to have records management as part of the responsibility. That would not only help with transparency and public access, but it also would provide guidance for cities. As I mentioned earlier, cities are fortunate because the Minnesota Clerks and Finance Association does update our general record retention schedule often. But that's not true for all local government, and not all local government has the capacity to do so. With that, I'll stand for questions.
Okay. Thank you, Ms. Gao. Any questions for Mr. Gemberling or Ms. Gao? Yes, Senator Osmick.
Thank you, Mr. Chair. Question on the retention for inbound traffic that may not necessarily be city emails, or just using that as an example. When I was on a city council, we had our own personal emails. We all have our personal emails right here. That would not, emails between individuals on their personal accounts would not be subject to this proposal. Is that correct? And I could take that from any of the 3, probably Senator Latz.
Senator Latz.
Well, I mean, the legislation that was proposed addresses emails, I presume, on government systems, but a lot of people are taking business emails on personal devices, and I suspect that's an area we'd want to make sure gets covered so that people can't feel like they can conduct government business on their personal devices and thereby avoid the implications for records retention and for data practices.
Senator Osmick.
Thank you, Mr. Chair. So Senator Latz, so if I had, as example, and I'm not promoting this, a Gmail account, and I was a city councilman, and I had another city councilman that I wanted to ask a question from or ask about what happened at a certain meeting. So how would you be able to unless those individuals CC a government account, how would you be able to regulate transmissions between personal email accounts in this particular case?
Senator Latz?
Mr. Chairman, Senator Osmek, that's an enforcement question. It'd be difficult to do that. And at some point in the process, you have to rely on the participants, the employees, the government actors to comply with the law, short of having the ability of a supervisor to go into every private account. In the end, even at the main level, it's the individual employees that are reading each email and determining which folder to put it into for retention purposes. I think Ms. Gao can amplify on my answer, though.
Ms. Gao.
Mr. Chair, Senator Osmek, actually, in terms of data practices, it doesn't matter if it's your personal email that you're conducting business on. If it's city business, then it's subject to the Data Practices Act. And if it is considered an official record, it also is subject to records management. Senator Latz does bring up a good point in terms of how would we enforce that. It depends on the type of city. If there are actually some elected officials, unfortunately, that don't have an official city email address. If they're using their personal email address and the data practices request comes in, or if they are just keeping their general records, they would still have access into that in responding to a request for litigation or as they're keeping their own records.
Okay. Yes, Senator Wickland. Thank you.
Thank you, Mr. Chair. I had a question for Ms. Cowell. Can you just tell me, the records disposition panel, where does that group reside, or what entity do they belong to?
Mr. Chair, Senator Wickland, it is actually 3 members who are part of the records disposition panel. So there's the state, they're either themselves or a designee. So it's the state archivist, the Attorney General. When it comes to cities, if it's for the legislature, it's the Attorney General, the legislative auditor for the legislature, and then the state auditor for cities.
Okay. Senator Jasinski.
Thank you, Mr. Chair. This is more of a logistical question. So in my inbox at work, when I'm going through emails, I obviously want to keep my inbox as small as possible. So I delete the items. I go into the deleted folder. How logistically does that work? Then if I go into my deleted folder and delete those, is that something that you're doing personally, or is that something done by a system administrator? Just more logistically how that works is I want to understand how that works logistically. So if you can go into that, that would be great.
Mr. Chair. Senator, so it depends on the type of system that a city has in place. So for cities or local governments that have an auto-delete, what they will do then is that it will, in your inbox, will automatically delete after a certain amount of time. In some of the policies that I've looked at, if you put it in the delete box, it actually still has an additional certain amount of time. So I was looking at one policy where it still resides in there for 14 days. Now for cities that don't have that auto-delete system, what happens is you have to manually do it. And some cities have it by a max in terms of how much data you can have within your email as a reminder or a prompt to actually delete out of your deleted box, or to make sure that the records that apply go into an archive folder or a different folder that's retained for longer.
Okay, let's move on then. Yes, Mr.
I'd just like to add a couple of things in response. Number one, historically, IPAD has never created records retention schedules, okay? That's a misstatement. And number two, I would never advocate this function be placed inside an executive branch agency given its history. Again, asking for money in state government for the last 20 years for this function has never received a positive response. Now, should there be somebody somewhere helping state agencies and local governments with these issues? Absolutely. But if you don't focus on the funding and where it comes from and whether or not it'll have support, given the history, it'll be another failure.
Okay, thank you. Okay, the next testifier is Mr. Keith Carlson and Rich Neumeister. If you could take your seats. And Mr. Keith Carlson, we'll let you start first, and we'll call you Mr. Carlson now.
Mr. Chairman, thank you. Again, I'm Keith Carlson. I'm Executive Director of the Minnesota Intercounty Association. And again, I also want to thank Senator Latz as well as Senator Limmer, who participated in the meeting to discuss this issue last week, and also indicate that I'm one of the participants in the separate meetings that have been occurring between us, representatives of the Newspaper Association and MINCOGI, to look at this issue. I think as the members of the panel, the committee have already garnered, this is an extremely complicated issue. It goes across both the current laws governing records retention as well as data practices. Emails may be governed by both. They may be governed by only one, or they may be governed under neither. Before I continue to go through my prepared comments, I just want to address some of the issues that have come up here. First, I think there's been a misimpression left by Mr. Gimberling that somehow there was a golden age when all our records were on paper and everything was available for historical research. Quite frankly, exactly the opposite was the case. To the extent all our business was done on paper, to the extent that document was not subject to our records retention policies, it went into the circular file, the wastebasket next to the desk of the recipient, if it did not have to be retained under a records retention policy. It was gone forever. It could never be retrieved. With the coming of email, without an explicit email retention policy, those records are available forever. And just quite frankly, local governments are just coming to grips with the fact that unless you have an explicit email retention policy, you're just being buried under all these information that's available for data practices requests, because each one of those data are available. It's available whether it's on your email server, whether it's on your desktop, whether it's available on your employee's smartphone, on his or her tablet. Voicemails are even available under data practices. It's available whether it's in your email server, in the deleted folder, in the archive folder. It's everywhere. And that's why, quite frankly, local governments are trying to bring some rationalization to this policy. Further, in terms of what type of emails have to be retained, this has already been covered. It's junk email. It's the infected email that you know that has a virus under Senator Latz's legislation. That would have to be retained. Personal correspondence of your employees, the emails that they receive from their children that are having a fight, the fact that it's been received at work, you have to retain it. The emails that get through the filters that purport to enhance your manliness or your femininity, it has to be retained. Constituent email has to be retained, but under data practices, it's private until either the recipient or the sender agrees to make it available. Now, many of you probably don't know this because data practices doesn't apply to the state legislature. It does apply to us, and quite frankly, it's a monumental task to comport with both the requirements of data practices as well as records retentions. As indicated by Ms. Gow's testimony, we've got to train our staff. We've got to implement processes to facilitate compliance and adjust those processes as the law changes. We have to have the facilities, hardware, and software to manage both. Access for the public, as I've indicated, has changed dramatically. It's gotten both simpler and more difficult. It's gotten simpler because they're electronic, they are somewhat easier to access, but it's gotten harder simply because of the volume of information that's out there. Again, unless you have an explicit email retention policy, you're talking about hundreds of thousands of documents, even for a smaller entity. Hennepin County alone spends over $3 million a year just on their email systems. And that doesn't begin to capture the cost of responding to data practices request. It's instructive, I think, frankly, on how a data practices request is actually made. So for example, if somebody wanted to find out what were the negotiations leading up to the acquisition of the trains that run on our light rails facilities and their cost of acquisitions, nobody comes in and asks for those documents. Basically, they come in and we as cities, counties, whatever local governments or state governments say, we will do a search. You tell us the terms that you want us to use. So light rail train, BUD, possibly one of the entities that fulfilled that. We would do that. And then we would get the results of the search, we, the government employees. Then those documents would have to be returned, would be reviewed by generally an attorney to see if there's any private, confidential, non-public data, and then that information would have to be redacted. Only once that redaction has occurred is the results of the search presented to the requester for their inspection. Up until that point, we have not recouped any of our costs for doing this. It's only at the point after their inspection that they request copies of those materials that we can recover some of our costs basically for copying those materials.
Mr. Carlson, if you'd wrap up.
Good. Mr. Chairman, I'll just mention for many of our smaller entities, the costs we're talking about are extraordinary. I've already gone through the complication of where they would have to search across devices, across all the folders that were referred to. But also right now, the general practice, I'm using my organization as an entity, we contract for email services, and basically we contract for a set amount of storage. Every few months, we get an alert from our ISP who provides our email services, has their email servicer, you're over your limits. We go in and we delete emails, basically the oldest, until we have enough space to get us through another several months. That's the practice in the business community. I'm sure that's the practice with many smaller entities. With legislation such as Mr. Latz, that sort of management would no longer exist. We would have to have much larger capacity so that we're sure that the email retentions, whether it's 180 days, 18 months, 3 years, would all have to be met and becomes a much more daunting management task. With that, I'll conclude.
Thank you, Mr. Carlson. Questions for Mr. Carlson, members? Okay. Thank you, Mr. Carlson. Mr. Newmeyer. Meister, sorry.
Mr. Chairman, members of the committee, for the record, my name is Rich Newmeister. First of all, for those people that are new to the process and being recently elected, I've included an article about myself. If on your own time you want to, it gives you a little bit of background about myself. I've done many data requests over a great many of years for myself. I've helped many nonprofit organizations, reporters, individuals, and all those kinds of things, entities and individuals. One of the important things to remember is that stakeholders are not just people who may be invited or attend a meeting or whatever, groups. They're individuals like, let's say, your constituent who is fighting an organization, a school district, or whatever it may be, about their children's rights, and want to know the correspondence for the last 2 years between teachers, between principals, counselors, or whatever about their kid. All the way to where it can be, well, I want to know how that decision about why my house or why the people in our neighborhood is something happening. I'd like to take a look at the communication and electronic documents over the past 2-3 years about that. Documents, emails tell you things. And these are not bland words of right to know. I want to, participatory democracy. These are all things that we all participate in. And I've been doing it for many a year. And so I know the importance of using the Data Practices Act to get electronic communication. I'll just give you some of the examples over the years that I've dealt with. And there's many. Many of I've brought to the attention of you legislators. I've also brought it to the attention of news media. GangNet, which was a thing that Bob Fletcher in Ramsey County had. Over 18,000 people were on it. Great many of those people were on it because of the color of their skin, from my perspective, and that was an article about it. The legislature dealt with that issue in 2010. License plate readers. Back in 2010, 2011, 2012, I was doing requests of various departments about license plate readers. And I found out that some entities, when they were corresponding with the lieutenant of the certain division or whatever, that there was discussion. Should we have a policy? Should we not? What really do license plate readers do? Well, they're to catch stolen cars. But then in the discussion of the electronic documents was more than just that. And as you know, you struggled with that issue for 3 years. Stingray, the issue about cell phone devices, tracking information about innocent people, plus the target. I was starting to discover in electronic documents and correspondence and those kinds of things 5, 6 years ago were about cell tower dumps that were being done without a warrant. And as you know, that was an issue that got involved in the media, and I was using, and then you as a legislator deciding this. All the way to citizens in Duluth, who I've helped along with someone else, wants to know why trees are being destroyed on 4th Street, because the county told them that we need to redo the street up there and we can't replace the trees and all that. Well, they asked for everything under the sun. And one thing you got to remember, the government has the power to say, okay, we'll give you a little bit here, a little bit there. They have a lot of discretion. So all of a sudden where this does a big, impact on the ability to give information, yes, but they have to take the time too. They have the discretion within the government. So what happened in Duluth, we found out that county commissioners and all that, and the engineers, they could have saved some of the trees. And this was just recently. There are many, many, many examples. One of the things that I would like to talk about is those principles. And the cartoon that you have in front of you here. Hi, I'm Mr. Government. We'd like to know more about you. Well, the point is that the citizen who they're coming to the door is saying, hey, if the government wants to know about us, do we have a right to know about the government? And that's one of the principles that's underlying this issue, that this is a participatory democracy, and in order for us to have government accountable, we need information. Information is power. I've illustrated to you some examples of how you can speak truth to power, whether it be on the local, on a state level, and a lot of it's happening on the national level too, but local and state issue is important, and there are many other examples. Now, many other states have 2, 3, 4 years examples. Florida, routine administrative correspondence, at least 3 years. Email policy development, 5 years. Routine emails are kept for 2 years. Washington State, anything with public business, 2 years. So, I mean, there's a lot of things out there. But, Mr. Chairman, the principle I want to leave you with, because there's principles here when we discuss some of these issues, is go back to the other side of the cartoon. You got 4 cartoons on the one side, and they're all barriers. There are already barriers here now to be able to get access to data, whether it be private about themselves or public to accountability. In the electronic age, you got more data on us, on decision making. And when you have more and more involved in our lives, there is an anxious public, other than just the stakeholders that are represented with groups and all that, but there's a lot of individuals. And over the last 3 years, I've been teaching a lot of individuals in public forums. And Mr. Chairman, as you may know, I was out in Burnsville, and a number of people are interested to learn about these tools. But then if all of a sudden things are disappearing under the realm of transitory, or where the individual employee can say, oh, I don't think the public should know about this. So, Mr. Chairman, members of the committee, there are many things. I've just done an email request from the city of Maplewood, and I'm looking at the back and forth to close a public meeting. And a public meeting was basically closed because they were using a security thing. Well, we don't want the public to know what we're discussing because it might raise issues of militarization of police. So, Mr. Chairman, members of the committee, there's a lot of principles and a lot of issues. Accountability and power for the people is one of the big principles underlying this debate. Thank you, Mr. Chairman.
Thank you, Mr. Neumeister. And might I say, before we get questions, we've appreciated your testimony over the years. You're a valuable asset to the community here. And I think you and Mr. Gimberling do it on your own dime. and it's been really good, so thank you. Questions, Senator Osmick?
Thank you, Mr. Chair. Mr. Newmeister, a comment and then a question. A comment is on your, sort of towards the end of your statement. Closed meetings are very specifically written into state statute. I'm not quite sure if it was as easy to say it was something that you perceived as should have been open, but when you close a meeting at a city council, there are very specific reasons, and then you have to make that record available. And I'm sure you know that after the proceeding and after, if it's a legal case or whatever the case might be, then they have to make that available to you, including all the tapes and information regarding it. So I think you understand that. But the question I had for you is, it sounds to me like you want to infinity and beyond as far as record retention. Is that a statement that you would agree with, or is there some level that you would be comfortable with for a level of records retention from your point of view?
Mr. Newmeister.
Mr. Chairman, Senator, 2 to 4 years.
Okay.
City of St. Paul kept their emails. This is kind of interesting. City of St. Paul historically kept their emails for 3 years because of some legal wrangling or legal issues. Because they're destroying, they kept them for 3 years. Now they're gone to a different policy. And one of the things that's driving this is the vendors. The vendors are driving, saying, we have these things, destroy right away, whether or not individuals. In regards to the individual meeting, I'd be more than glad to tell you a little bit more. You're right, there are specific things in law. This was closed under the security provision. It was like a security briefing. But one of the things I was able to get was emails discussing what is security information and all. And that's what led me to the question, and where I publicly talked to the individual. From my perspective, I didn't go to the newspapers with it or anything like that. But
Okay, thank you, Mr. Newmeister.
thank you.
Let's bring up 2 more testimonies. Mr. Harper and Van Pelt, Sheila Van Pelt. Let's start with Mr. Harper, who represents the League of Minnesota Voters, League of Women Voters of Minnesota.
Yes. Good morning, members.
I have to ask you first, my question that came up. Sorry. Are you a member?
I am a member.
Okay,
you can't see from the distance, but my pen says not just for women.
Oh, okay. That's what I didn't know.
We do have both men and women members, yes.
Sure, proceed.
Good morning. My name is Nick Harper, and I am a member and volunteer with the League of Women Voters of Minnesota. Thank you for allowing me to testify today. As you likely know, the League grew out of the effort to secure for women the right to vote. Along with protecting the right to vote for all citizens, we believe that governmental bodies must protect the citizens' right to know by making public records accessible. Most importantly, I want to note that the League does not support or oppose any candidate or political party. The League of Women Voters of Minnesota supports Senate File 123 and its decision to create a minimum retention period for electronic records. This bill protects the citizens' right to know and ensures that public data remains accessible. Keeping public data accessible is necessary to ensure that the public remains informed of government actions and that government bodies remain accountable to its constituents. In particular, requests for public data can give insight into the actions of regulatory, administrative, and bureaucratic entities. Such information is critical to maintaining accountability with unelected government agents. Furthermore, retention of electronic records is increasingly important as the majority of regular actions in government are taking place in electronic mediums like emails, chat messages or instant messages, and texts. Due to the growth of technology, there is no longer paper trails. Instead, there are data trails. And the government must preserve that data long enough for the public to obtain access. Finally, this bill is urgently needed because some local government entities are decreasing retention periods to as short as 30 days. Such short time period effectively erases the data before a person can request to inspect or copy the data. These short retention periods remove the ability of citizens to remain informed of government action. These retention periods undermine transparency and accountability and are against the public interest. While we recognize that there are costs with this bill, both in terms of staff time and technology expenses, the League of Women Voters believes that the public's right to access its own data is invaluable. We recognize that the bill is not up for vote today, but if it had been, we would have urged you to vote in favor of it.
Thank you, Mr. Harper. Any questions for Mr. Harper? Okay, seeing none, Ms. Van Pelt. Introduce yourself, please, and continue.
Chairman Hall, members of the committee, my name is Sheila Van Pelt. I'm a citizen advocate. I've been here for about 5.5 years, and a lot of my work stems from being one of those people Rich Neumeister discussed, and to a point, Mr. Gemberling, about being those citizens who are actively involved and for reason and wanting data for particular reasons. In this, the bill that you have here, I'm so pleased that you brought it before. And even when there was an article in the Star Tribune, I've reached out to your LA Pat to commend you for doing, and bringing out a time to talk about this. My work has been with various areas in state government, and I understand this is local government, but what there is movement between both of them that I believe what my learnings have been transcend both. I'd like to, from previous comments made, key words or key statements have been made. Mr. Gemberling had 2 of them. We need to keep our history. Another one, keep government accountable. Rich Neumeister just said information is power. And I will add to that, information promotes competency. When we do not have history to look at, we lose out. And sometimes, like for my own circumstances, I didn't know what information I needed to really ask until a later point in time when I started putting pieces of the puzzle together. Now, if we don't have a longer retention schedule, I or any citizen like me will lose out. And data is just key and it's helpful, and the shortened retention schedules will not help us. An example would be, for instance, for me, Minnesota Department of Health, if I may speak on a statewide level. They did an investigation into a facility. Well, I only learned much later on that they investigated the wrong facility. Okay, and then a number of red flags that I've presented to them that go unnoticed, and I keep wondering why. These are fact-based scenarios, and I want to know why, and it's necessary to get those information to piece things together. And I want to just emphasize to you, when public employees work, they work for us, the taxpayers. I don't believe their work is private. And they need to be accountable to us. We pay them to do their job on behalf of us. And so we should be able to view, obviously there's within reason, legislators have their separate side, but there's no reason to not have an accounting and a looking in, especially when history can be explained or how decisions came about. When we lose that information, we lose our ability to learn. And one thing I want to mention to you too, I've done multiple data practices requests. And in an article the testimony that I read through with sitting here that Mr. Webster gave, it talks about if we have these shortened timelines, look at all the delays that he had to go through. We have data practices requests, and if it's on personal data, you're supposed to have that data honored in 10 days. Now, I have made them to the Office of Governor Dayton, the Minnesota Department of Health, the Department of Human Services, and to another department, and I get pushback, nothing, not even acknowledged in many cases. And what I do want to impress upon you is we have statutes. This is going to extend a little bit beyond this, but we need to contain and control what we have. We have data practices that are there for the individual person or a group or whomever to ask and get data. It is their right. And what I recognized in this testimony, he said, is the foot dragging. Okay, I'm witnessing foot dragging, and in the time that continues to go on, data can be destroyed. And when we have statutes for the data practices, we shouldn't be allowing for that. And so I just wanted to say, if we can also look at our data practices, that we eliminate people playing with the system, meant to hold us up or take away what we want to know. It's unnecessary and uncalled for. And I will say quite honestly to you, all of you, in making these data practices requests, I am ignored until I have the intercession of chair people making requests on my behalf. Now, this can be in a local community. Why is that the case? Just because I happen to know a lot of information that doesn't want to be out there is no excuse. And what I would like to note is another thing. We need to be critical of the data that we receive. This is fact-based. I've made a data practices request for a very specific certain period of time, and I'm only getting part of the data, and I know what data's not there. Even by a person telling me they have some information and it didn't show up in the data practices request. So we need to look at what information we are getting and be critical of it, because when we have people within these own agencies, wherever they may be, or local government, they are looking through their own emails and deciding what they're going to give you. Now, is that being that they're blind and just giving everything, or are they looking for the data that might be most damaging to not give? That has been my experience. Another thing I wanted to touch base on, just to extend it, is to the work of IPAD. And I've met and worked with Stacy Christensen because I've had non-compliance with data practices requests. Their budget, from a Star Tribune article this weekend that I read, even when we talk about the fading voice of an access advocate, written by James Eli Schiffer, we have a budget of $493,000 for 4 employees. And when we ask for an advisory opinion, which I have, there is citing back to previous cases. Well, every case is unique and different. And when we do only cite back, we're not doing justice to that individual, because we are having foot dragging, as is even exemplified in this article as well. And how are we compelling, and what parameters are we putting around those who are having the data requests put upon them to comply? And until I really see that IPAD can take a more active role versus what I hate, and I don't want to be construed wrongly, but citing previous work, we're not getting what we need from our end. And so I'd like to even promote that idea of increasing their budget or having more of an active role so they don't become obsolete. So in closing, I just want to touch on those 3 words. We need to keep our history. We need to keep government accountable, as I was mentioned from there. Information is power, and to my own words, it promotes competency. Thank you.
Thank you, Ms. Van Pelt. Members, any questions for Ms. Van Pelt? Okay, thank you.
Thank you.
We do have a testimony from, a written testimony from Tony Webster. The audience could find those, I'm sure, wherever the material is. And members, you have that in your packet. Senator Latz, we have about 11 minutes. Would you like to wrap up? And also, I guess before I do that, Senator, are there any other public persons that would like to speak on this subject? Seeing none. Senator Latz.
Thank you, Mr. Chairman and members. I'm a veteran of the license plate reader discussions and the body camera discussions as they related to data practices. The chairman was on the Judiciary Committee when we had those discussions as well. And so these can be highly contentious and complicated issues. And I served for 9 years on a city council, so I saw closed meetings come up on occasion and citizens seeking information. And again, these are complex and they're fraught with public interest, and sometimes the public doesn't even know what it is they should be interested in knowing. On the other hand, this can be enormously expensive databases to maintain. And governments are indeed stewards of taxpayer dollars as well, and should not face the obligation of retaining data that is frivolous or unnecessary for some other reason to retain. And there we have to strike a balance. And while my own inclination is to strike that balance in favor of a longer retention period so that we have more availability for the public to access information, for historians to understand how decisions are made so we can all learn from it, and so that public policy can be shaped and to provide accountability for those who are making decisions. I think we still need to factor in the element of expense at the taxpayers, out of the taxpayer's wallet, because we have just enormous amounts of data that are coming in, that are being exchanged, that are being stored, and whether it's being stored on a small town's servers or whether it's being stored in the cloud, there's an expense to it. And I'm not a techie. I'm just touching the surface of some of this stuff. The techies are the ones who really understand just how much data is out there. And even though storage costs are going down, for some communities, they're a very significant portion of the budget, and they're growing. And the longer that you keep everything, it just grows exponentially and with little end in sight. So we need to factor that information into our decision-making as well. Efficiency is not an enemy of accountability. It is a factor that we should consider. With that said, I want to thank the testifiers for coming forward and providing this information. Every time I talk about this subject, I learn more about it. And it's my hope that either this session or next session we can come up with some ideas that we can modernize our statutes, give a bit more guidance to our governments, and protect the important data that we need to protect so that we can keep government accountable as well. So thank you for your time, Mr. Chairman. I appreciate it very much.
Senator Latz, any other questions for Senator Latz? I would like to, first off, is my understanding true that it's the cost, the largest cost that we're concerned with, the local governments, would be the data requests versus the storage? Do you know?
Mr. Chairman, my impression is yes, that certainly the greatest expense is in the cost of the personnel to respond to requests for data, especially data requests that are blanket data requests. If there's a request for specific correspondence or decision-making information relating to a particular small project in a small town, that's one thing. But if you get a request that comes in and asks for all records for the last 2 years that relate to zoning decisions in the town, and then you've got to go back and it's not just the search. The more important time-consuming expense is reviewing all of those records, because someone has to review every record that's created to make sure that there isn't data that is not public, that's private, that's confidential, that's classified under the Data Practices Act, doesn't get released publicly. Because if they erroneously release it, they're not only violating someone's potentially private interests or privacy, but also they're opening themselves up to liability for having released that information when they shouldn't. So yeah, it's pretty serious, and then they got to redact it, and then there's the expense of training people so that they have sufficient knowledge of these complex statutes to be able to recognize what can be released or should be released and what cannot or should not be released. And often, cities and towns, they don't have that expertise on staff. Senator Ralph can probably tell you, as advising cities, representing cities in this stuff, how complex it can be, and he's probably been called upon to make some of these decisions or help train staff or to do it himself with his practice.
Senator Ralph?
Yes, thank you, Mr. Chairman. You actually touched on what I was going to kind of query about, and that is this whole issue of not only do we have to extract the data, extract the records, but the high cost of redaction, of review, and the possibility for error. And I'm very concerned about that as we go forward. As you indicate, I used to represent cities, and this is especially when we get into the criminal aspects of it, and these releases of criminal records upon the closure of investigations and how we deal with that. This becomes an immense expense to the counties, to the cities, and we need to factor this into whatever we do, not only in the retention, but then in the management of those files. So I appreciate your comments on that. I think that's very, very well taken and very important.
Mr. Neumeister, do you have something you want to add to this shortly?
Mr. Chairman, for the committee, I thank you very much for this opportunity. For 40 years, it's been a policy of our state that for the public, you can inspect for free. And one of those premises of that is that it's been for 40 years in state law that the government entities have to develop their systems for convenient use for themselves, but also for the public. And many government entities have thought of the public in mind for public access. Some haven't. And all I'm saying is that when you talk about cost, yes, but for inspection and all that, that becomes a big barrier for able to get access to government information, which is very important.
Members, any more questions for Senator Latz? Hearing none, Senator Latz, thank you for your testimony. I do really hope that you can find a compromise here. I think it's important, and I appreciate you having this bill, and whether we get it done by the end of this session or, working on over the summer, I think we really need something. So thanks for doing this.
Thank you.
Without any further business, this meeting is closed.